Good morning and welcome all to the Network for Public Health Law's webinar titled Vaccine Mandates, Assessing Their Legalities. Our speakers today are Leila Barraza, JD MPH, Associate Professor at Sacramento College of Public Health, University of Arizona, Senior Consultant for the Western Region of the Network for Public Health Law. Peter D. Jacobson, JD MPH, Co-Director for the Network Mid-States Region, also Director for Center for Law, Ethics, and Health at the University of Michigan School of Public Health. And Erica N. White, JD, Research Scholar and Staff Attorney for the Western Region at the Network for Public Health Law at ASU San Diego Connor College of Law. Today, we'll be discussing state vaccine mandates, including litigation and legislation, followed by federal vaccine mandates, policy and practice implications, and then we'll go into a Q&A. First, we begin with state vaccine requirements, going into litigation.
Thank you, Emily, for that great introduction. I will start us off with the state aspect of vaccine mandates and some recent litigation in this area. We have, I see some notes about sound, so please let us know if you can't hear us in the chat. Thank you. So to start us off, I'm going to introduce a couple of recent slides surrounding state vaccination requirements and the requisite litigation. And then I'll follow up with some trends in what we're seeing with some recent legislation. To start us off first, we have Valdez v. Grisham in New Mexico, where a healthcare worker and an individual who wished to attend the New Mexico State Fair brought a class action complaint against the Department of Health, claiming that, and the state, claiming that the governor's public health order violated state and federal civil protections. And per the public health order, hospital workers that were eligible for COVID-19 vaccination were required to receive the vaccine, and eligible attendees of events such as the New Mexico State Fairgrounds had to show proof of vaccination. In this instance, the plaintiffs, the healthcare worker and the individual wanting to attend the state fair without showing proof of vaccination, brought a lawsuit, and the U.S. District Court refused to block the public health order, finding plaintiffs failed to make even the baseline showing required in the suit. And we'll demonstrate this as kind of a theme related to vaccine mandates in their litigation, that the courts have generally been upholding state vaccine requirements, such as this in New Mexico, where a healthcare worker was required to get vaccinated. Next slide, please. Along those similar lines, in Maine, there was also a lawsuit brought by healthcare workers challenging Maine's law requiring workers in healthcare facilities receive the COVID-19 vaccine. They argued that the requirement violated their sincerely held religious beliefs, and alleged that the lack of religious exemption violated the First Amendment. The court went to the First Circuit Court of Appeals, and the First Circuit refused to temporarily halt enforcement of the Maine state law, finding that the law was neutral toward religion and generally applicable to all healthcare workers, and cited the state's interest in preventing the spread of COVID-19 and finding that that satisfied rational basis review. This First Circuit noted that Maine has not allowed religious or philosophical exemptions to any of its vaccination since an amendment to state law back in 2019, which it noted was before the pandemic even began. And the First Circuit also noted that the COVID-19 mandate satisfied that state law, and that the court also referenced that Maine has long required that healthcare workers be vaccinated against infectious diseases. It noted that the court noted that Maine considered other options, for example, daily testing, but showed that the other options were inadequate to achieve its goals, which included keeping healthcare facilities staffed to care for all patients, whether they were COVID-19 patients or otherwise. The First Circuit decision then in that ruling, then the plaintiffs following that ruling applied for injunctive relief from the US Supreme Court, asking the court to temporarily block the enforcement of the law while the case continued through litigation. And the application for injunctive relief for the temporarily blocking the state law was denied by Justice Breyer. Justice Gorsuch, and joined by Justices Thomas and Alito, dissented from that denial. And the dissent argued that Maine's law was not neutral because the state allowed those invoking medical reasons to avoid the vaccine mandate. Next slide, please. The next case I want to mention is Wise v. Inslee, Governor Jay Inslee. And in this case, employees of multiple state agencies, local government entity, and a healthcare provider sought to block the governor's proclamation that all educators, healthcare workers, and state employees receive the COVID-19 vaccine. The plaintiffs claim that the proclamation violated state and federal laws, including religious freedoms. The federal district court declined to issue the injunction, again, declined to temporarily block the enforcement while it went through the judicial process, because the court claimed the plaintiffs had not demonstrated a likelihood of success on religious freedom claims. The court also found that the mandate would not cause irreparable harm to plaintiffs. And in that, the court cited prior cases, some other legal precedent, finding that loss of employment was not did not constitute irreparable harm. And the court also found that the public interest strongly favored the state's position. The proclamation affected approximately 680,000 workers in Washington state. And the district court judge noted that the proclamation was clear to slow the spread of COVID-19 without any discriminatory objective, and it applied equally to all educators, healthcare workers, and state employees and contractors. The court also found that the proclamation was rationally related to this interest, as I have a quote here from the decision. Next slide, please. The next case I want to mention is Dr. A Hosho and We the Patriots v. Hosho. And the plaintiffs were 20 healthcare workers challenging the state's requirement that all healthcare workers receive the COVID-19 vaccine, arguing that the requirement violated the First Amendment because the requirement did not include a religious exemption. In this case, Justice Sotomayor declined to temporarily block enforcement of the requirement because, but in her declining, Justice Gorsuch and Justice Alito dissented from her denial of the decision to decline to temporary block enforcement while the court case was continuing in litigation. In the dissent, Gorsuch cited his prior dissent in Does v. Mills, referencing that allowing medical exemptions should also mean allowing religious exemptions. And the dissent has a quote, allowing a healthcare worker to remain unvaccinated undermines the state's asserted public health goals equally, whether that worker happens to remain unvaccinated for religious reasons or medical ones. So that was the dissent's argument. But again, here, the US Supreme Court, under Justice Sotomayor's decision, declined to temporarily block this challenge to the healthcare worker requirement in New York. Next slide, please. And then last case, I have the case against Teal versus the City of New York. This includes 15 public school employees who claimed that they faced permanent termination for not being vaccinated for COVID-19. They cited religious grounds for their objection to receiving the vaccine, and argued the city's religious exemptions were too narrow. In February, just recently, February 11th, Justice Sotomayor declined the emergency request to temporarily block enforcement of the city's vaccine requirement for these public school employees while it continued in litigation. However, the plaintiffs then resubmitted their application to Justice Neil Gorsuch, and in a few days later, then February 16th, without comment, the case was referred to the full court. So this case will be one to watch to see what the Supreme Court does in this instance, and whether they continue to decline to block state vaccine requirements, or if they change course and change their prior decisions, as we've seen in some of the cases already I've mentioned today, and actually allow the mandate to be stopped, or continue to allow it to be implemented. Whether they allow it to be implemented or block the implementation will be decided as they continue to consider these cases. And whether they change course or continue will be ones to watch out for, and will be kind of opined and discussed a little bit later in this webinar. Next slide, please. I'd also like to mention some legislative trends that we've seen this year so far, just in this few months that we've had of 2022, and related to vaccine requirements. Next slide, please. So a couple trends that we've seen, there obviously are all varying kind of introduction of bills throughout the states that have been seen so far this year. So I'm just going to highlight a few in the limited time. And the first one I want to highlight is one out of Arizona. And this is a bill that would prohibit the COVID-19 vaccine from being required by any governmental entity. And this is similar to bills that were introduced in many states last legislative session of 2021. And again, a theme that we're seeing in multiple states again this year. And this is one example here in Arizona, where a government entity would be prohibited from requiring a COVID-19 vaccine. Next slide, please. Along the similar theme is a bill that was introduced in Georgia. And the wording of it is problematic potentially for public health because the current wording, or in the introduced version at least, was that no agency shall require proof of any vaccination of any person as a condition of providing any service or access to any facility issuing any license, permit, or other type of authorization, or performing any duty of such agency. The original, when this was introduced, there was a lot of concern as to whether this would block inclusion of blocking public schools from requiring any vaccine, since the bill does say require proof of any vaccination. And that obviously goes against the traditional and historical requirements that states have for requiring vaccines for school entrance. In this case in Georgia, there was public concern, and the bill sponsor noted that he would amend the bill to narrow it to specifically just the COVID-19 vaccine. But again, another example of legislation that has been seen thus far. Next slide, please. I know I'm running low on my time, so I'm going to quickly go through these last couple slides so my co-presenters have time to present their slides. But this slide introduces an opposite trend of requiring the COVID-19 vaccine. So instead of prohibiting requirements, state requirements that would prohibit COVID-19 vaccine from being required. In California, there was a bill introduced called the Keep Schools Open and Safe Act. In this instant, Senator Pan introduced this. It would add COVID-19 to the list of required vaccines, and in doing so, would allow only for medical exemptions and restrict it from being any non-medical exemptions to the COVID-19 vaccine. Next slide, please. And in Louisiana, the governor of Louisiana, Governor Edwards, back in late 2021, announced that it would continue with a rulemaking to add the COVID-19 vaccine to the required lists for school entrance, just as other vaccines were already required for school entrance. And that is another example of the addition of the COVID-19 vaccine instead of some of the prior examples, limiting requiring COVID-19, but instead adding it to a requirement, for example, in this case, school children for school entrance. And that is the end of my slides for state mandates. And I would like to pass it to Erica to focus on federal vaccine. Thank you very much.
Thank you, Leila, for that great overview of these state vaccine mandate cases. So now we're going to shift our focus from state to federal and look closely at 6 federal vaccine mandates and assess their legalities. Next slide, please. So I'm sure you're all familiar with the OSHA standard. The Supreme Court struck it down, so it's all over, right? Federal vaccine mandates are things of the past. Well, that could not be more incorrect. There is still so much going on with these federal mandates in court and serious policy implications down the line, as we'll hear about from Peter later on this morning. Next slide, please. So one reason these federal mandates are so essential is that they completely preempt conflicting state and local laws. We saw a few of those from Leila just now. Several states have forbidden vaccine requirements entirely. So without existing federal mandates, there would be no way for these states to require vaccines. And federal mandates offer a uniform standard instead of a patchwork of approaches. Although public health has traditionally been a state power, federal entities have authority to regulate in these areas as well. So now let's turn to the first of our 6 federal vaccine mandates we're going to look at this morning. Next slide. All right, so on September 9th, President Biden announced his action plan, the Path Out of the Pandemic, directed at the Department of Labor's Occupational Safety and Health Administration, to develop an emergency temporary standard for all large employers with over 100 employees to ensure their workers are fully vaccinated or undergo weekly COVID-19 testing. This is the only vaccine mandate we'll look at today that has this testing alternative. The OSHA ETS was released 2 months later on November 4th. The very next day, numerous states, businesses, and nonprofit organizations challenged the standard in courts of appeal across the country. On January 13th, in a special session coming back from their holiday vacation days early, the Supreme Court granted the challengers' request and issued a stay, forbidding OSHA from enforcing this standard after finding that the applicants were likely to prevail on their merits of the claim and succeed in their challenge of this rule. This was, of course, a major blow to President Biden's vaccine strategy. If the mandate had been allowed to stand, it would have affected about 84 million employees, more than half the labor force. But this really has far deeper implications for the federal government's legal abilities to protect the public's health and safety. The court here found that the OSHA mandate exceeded the agency's authority. But was the standard really in excess of OSHA's powers? Congress enacted the Occupational Safety and Health Act in 1970, creating OSHA, which is tasked with ensuring occupational safety or safe and healthful working conditions, which it does by promulgating standards. The majority in this decision said Congress only intended to give OSHA the power to address workplace hazards. They distinguished COVID as being in a different category, one of day-to-day dangers we all face. If the court's legal reasoning is followed, it would be nearly impossible to promote the general welfare of the public by casting doubt on all regulations that have, quote, vast economic and political significance. As Breyer, Sotomayor, and Kagan said in dissent in this case, the court's order seriously stymies the federal government's ability to counter unparalleled threats. Next slide. Now, let's turn to the Centers for Medicare and Medicaid Services rule. On the same day that OSHA standard was announced, President Biden announced a requirement that healthcare workers at facilities participating in Medicare and Medicaid programs are fully vaccinated. Healthcare organizations risk losing federal funding from Medicare and Medicaid if they don't comply with the mandate. The rule was also hit by many lawsuits across the country. In late November, various district courts issued preliminary injunctions blocking this rule. And in January, the Supreme Court heard oral argument over this rule in a joint session with the OSHA standard. But here, the Supreme Court allowed the CMS rule to be enforced. What's the difference? On their faces, these two vaccine mandates are similar, two federal agencies promulgating rules incentivizing vaccine uptake. But the legal authorities are completely different. Here, the agency is acting through its authority to impose conditions on facilities' participation in the Medicare and Medicaid programs. Hospitals and other medical facilities who want to receive federal funds and participate in these programs, which is virtually every facility in the country, must comply with certain requirements. Money talks, right? Congress has given CMS broad authority to require conditions on participation in this program, and CMS has long acted on this, and the court has upheld their ability to do so. Next slide. In April 2021, months before the other vaccine mandates, the Biden administration began to ask all federal employees to self-attest to their vaccination status. And then again, as part of his path out of the pandemic plan in September, President Biden supplemented this requirement by eliminating the testing option, requiring vaccination for all executive branch employees. This requirement had largely been unchallenged in courts, at least compared to the other rules we're discussing today. The president has broad traditional authorities to regulate the rest of the executive branch. He is the head after all. However, this rule is not as safe as it may seem initially. Following the Supreme Court's logic in the OSHA case, some courts have changed course. On January 21st of this year, days after the OSHA and CMS decisions, a federal district court judge in Texas issued a nationwide preliminary injunction, ceasing the rule's enforcement. This decision relied heavily on the logic in the Supreme Court decision, finding that somehow President Biden lacked the authority to regulate his own branch. And on February 9th, a few weeks ago, the Fifth Circuit declined to block the lower court's order barring the mandate. So today it remains on hold while litigation ensures. Next slide, please. Biden's mandate for federal employees extended to contractors and subcontractors. This requirement had been challenged as exceeding Biden's authority as it extends beyond federal employees to workers employed by private companies, but hired by the federal government. This rule had been challenged multiple times, more than any other requirement other than the OSHA standard. It was challenged in 6 federal district courts and appealed to several courts of appeal. And the mandate is currently on hold, like the federal employee rule, while the appeals process is ongoing. Next slide, please. So in late August of last year, the Secretary of the Department of Defense issued a mandate for all service members of the U.S. Armed Forces on active duty or in the ready reserve to receive COVID-19 vaccines. The Secretary directed each military department to use existing policies and procedures to manage mandatory vaccination of their service members. This mandate was not particularly controversial either until the OSHA ruling. The military branches have required service members to receive vaccinations for years, even going beyond what is required by other mandates. For example, following the 2001 anthrax attacks, members were required to be inoculated against anthrax. For months, we saw challenges to the different branches' COVID-19 requirements be denied by courts across the country. But now, limited numbers of service members are winning individual challenges based on religious exemptions requirements. One other thing to note when discussing the military mandates is the National Guard, which is a joint federal and state effort. Many governors and states' attorneys general have declared that their state's National Guard members are solely their domain. They argue that they are commander-in-chief over these individuals, and that they have the authority to decide whether or not they'll be vaccinated. But this is contrary to precedent. The National Guard are militia members subject to federal oversight and regulation, long established by Supreme Court precedent. So far, courts have upheld the military mandates as applied to active members and National Guard. But as applied to civilians, the mandates are on hold while the challenges to federal employees and contractors play out in court. Next slide, please. The final mandate we're going to discuss this morning is the Head Start mandate. I find that this one is often forgotten when discussing vaccine requirements. It's just a smaller program. Head Start is a federally funded program serving vulnerable and underprivileged young children under 6. Also, as Biden's big vaccine initiative in September, the president announced his administration's plan to require all educators in the Head Start program to be vaccinated. In November, the Administration for Children and Families, an agency within the Department of Health and Human Services, issued a rule requiring masks for all children under 2 years of age and older, and vaccination for all Head Start staff, contractors, and volunteers. Similar to the National Guard challenges, opponents of this rule argued in court that the Head Start programs are administered by the states, outside the scope of federal authority. So far, a suit in Texas succeeded in staying the rule in that state, and another suit of 23 states led by Louisiana was similarly successful, leaving this rule on hold in half the states while the appeals process continues in courts. Next slide, please. So where does this leave us? The Supreme Court could very well this year hear challenges to the federal employees, contractors, military, or Head Start mandates, and any number of state mandates that we heard about from Leela this morning. The OSHA Supreme Court ruling really changed everything when considering the present and future of vaccine mandates. Federal powers seemingly long established, such as agencies' authorities to promulgate rules and the executive branch's authorities to regulate its own members, are being challenged in novel ways. And these challenges are being handled quite contrary to how you may expect. So now I'll turn over to Peter to explore further.
Thank you very much, Erica. Thanks, Leela and Emily. Great presentations. As you can see from Leela's and Erica's presentations, there's a lot of litigation. It's hard to discern real trends and draw conclusions from them. And what I want to do is talk about some of the potential concerns. Next slide, please, for the litigation, and then some of the policy implications and the, pardon me, early season allergies, I'm afraid, and the potential practice implications. And we want to leave a lot of time for questions and comments about what we presented today. But I think we need to step back for 1 second and frame the context. And all of you are familiar with this, but I want to have it in front of us because it matters for how we think about the policy and practice implications. And I want to focus on 2 background contextual aspects. The first is that COVID-19 is, we hope, a once in a century pandemic event. And as you'll see, my concern here is that we're developing litigation and policy based on this once in a century event that may affect routine public health in adverse ways in future years. And the second is, we see this on a daily basis, the exceptional political polarization that we're undergoing in the country. It makes it very difficult to respond with a consistent political strategy. And I guess the third is to keep in mind that public health is a political enterprise. It doesn't really exist outside of political accountability. That places some constraints on public health, but it also forces accountability. So let me start with the potential litigation alarms. I couldn't think of the exact word I wanted in framing this, but it's fair to say that Jacobson versus Massachusetts, the 1905 case that basically granted broad authority for public health to intervene to mitigate pandemics and infectious disease outbreaks through mandates. And I won't go into that case because most of you are familiar with it, but suffice it to say that that case is undergoing more direct challenges than it has in probably since it was decided over a century ago. It's foundational for public health. So any attenuation of the ruling in Jacobson versus Massachusetts will have the effect of limiting public health authority. And second point is and it gets to what Erica was talking about in some of these mandates, and that is the shifting view of the separation of powers. Our governmental system really depends on separating the powers between the three branches of government, but it also mandates and requires checks and balances to work effectively. And again, as Erica noted, there's some question that the Supreme Court is arrogating too many powers to itself at the expense of either congressional activity on the federal level or potentially state level activity. Although that is tempered by the fact that there may well be a shifting view of federalism going on at the Supreme Court, which again, for lack of a better term, prefers state action to federal action. I think one of the things we see in the litigation is the court has been reluctant to undermine state and local activity. After all, public health is fundamentally a state and local activity. And the court seems to be more closely scrutinizing federal activity, the mandates, although again, as noted, the court allowed the CMS mandate to stay because it had a very firm statutory basis. But just think about that as a potential trend. And as noted, the potential exemptions for religious practice will remain a very contentious litigation issue over the next few years. At both the federal and state levels, there is some concern, I think, about what's called the non-delegation doctrine. Basically, it means that Congress or a state legislature cannot delegate to one of the other branches functions that it is constitutionally required to provide. The concern here is that in a modern administrative state, Congress can't really decide all of the questions that need to be decided. A state legislature, for example, can't very well adapt nimbly and with precision to an unfolding, uncertain infectious disease like COVID-19. So preventing using the non-delegation doctrine to prevent the professionals from acting is a serious concern. Whoops, next slide, please. One way to think about the litigation and these potential trends is that we're seeing some what I would call sentinel effects. It means that they're indirect. What I've been talking about so far would be direct effects, but there are some indirect effects. For example, Wendy Parmet and others have noted that there's an increased burden as a result of these cases on justifying the intervention, especially the lockdowns and the mandates have been very closely scrutinized, and in the burden on justifying the mitigation strategies or on public health departments' justification for the mandates, lockdowns, et cetera, mask wearing has been ratcheted up. And that's a real concern because if you place that burden too high, it again undermines the ability to regulate effectively to stop the spread of the virus. Clearly, there's a skeptical view of science and professionalism. I don't want to suggest that the courts are as much as the legislatures are, and I'll come back to that in a minute. Limits on authority. This is a major theme throughout my presentation. Are the courts and the legislatures placing too many limits based on this once in a century phenomenon that will redound to the detriment of the public's health, of population health in the years to come? And I'm afraid the answer is yes. And we'll come back to that. And in that sense, it encourages these trends, these skepticism of authority and the increasing constraints that courts may be placing on public health professionals only encourages legislation to limit public health authority. And that gets back to this idea of political polarization. In a naive, perhaps an ideal world, if you had a Democratic governor and a Republican legislator during a pandemic, set aside the politics, come to some agreement on how to mitigate the spread of the disease. Didn't happen. And whether it should have happened is a very different question. Next slide, please. So what are some of these litigation and more explicitly legislative attacks? In some states, we've seen laws, as indicated earlier, just limiting public health authority, just placing limits on the broad grant of authority. Limits on enforcement. One of the outcomes, I think, of the resistance, that I'll get to in the next slide or so, is very limited enforcement of the orders. Law enforcement was really reluctant to enforce these orders, and the legislatures weren't intervening in enforcing greater enforcement. In some states, even worse, in my view, there's been a shifting of authority from public health to elected officials. Now, I don't frankly understand why the elected officials want this authority, but in Kansas and other states, they're getting it. What are they going to do with it? It undermines professionalism. And in two areas recently, one in Colorado, one in California, rural counties have shifted. They've opted out of the governmental public health system and are funding private entities to conduct public health. My guess is that's going to be fairly limited. I'm more concerned about the shifting of authority to elected officials, and maybe in the Q&A we can come back to that. And my colleagues in the Western region of the network have focused a lot on preemption, and this was mentioned earlier. I think that's a concern at the federal level, but it's a greater concern, it seems to me, at the state level, preempting local health departments from taking aggressive actions during a pandemic. Next slide, please. The resistance to public health orders is hardening. And in a sense, public health's collective ethos of protecting the community is colliding with what we're seeing as rampant individualism. I don't want to take the vaccine. I have freedom. I can decide what to do. Of course, that simply elides the effect of my decision on others. And that's exactly what public health is designed to prevent. So what does that mean? Getting back to the enforcement, it really creates difficulties in enforcing the law. The attacks on vaccines, especially childhood vaccine requirements and HPV, is a real concern, because if the resistance continues to grow, although I suspect that it's not going to grow much beyond where it is now, and will probably recede once the pandemic ends, at least I hope. Nonetheless, what's the residual effect? Are we going to see legislatures reducing requirements for school and childhood vaccines? That would be tragic if that's the result. And there are concerns, I think legitimate concerns, about recruiting public health professionals. If I live in a state that has just shifted authority away from the health departments, how am I going to recruit highly qualified professionals who will have very little control over the decisions they make? And one of the fundamental challenges remains, how do we restore trust in public health, given the assaults on health officials that we've seen over the past 6 months to a year? Next slide, please. Okay, what are some of the post-pandemic strategies we'll need to focus on? Messaging. We all know it's not been great, and that's, I'm sorry to say, a serious understatement. We need to talk to communities about a return to routine public health and why we can't equate the two being the COVID-19 and what health officials do on a day-to-day basis. We will develop litigation strategies to preserve Jacobson versus Massachusetts. A lot of my public health law colleagues at the George Group and other organizations are doing that right now. And I'm confident that they'll come up with really good answers to the problem. We also, I think, need to conduct some evaluations on how the shifting of public health authority from health departments to the direct political control will affect communities. Am I correct that this is a bad trend that will have deleterious public health implications? We should study that and evaluate what this means so that we can then go to the legislatures and advocate for change and saying it is not, it's been a bad outcome. Next slide, please. We need to develop alternative strategies that avoid mandates. I think we are going to have a difficult time returning to mandates, lockdowns. The hardening of the resistance, I think, will make it very difficult for elected officials to continue that strategy. The mask wars continue. We'll need to develop new enforcement mechanisms. How do we connect back to law enforcement officials so that they will buy into the need to enforce? I've been talking a long time that we need to develop a public health voice. We still lack one, which will then help us develop new legislative strategies for what I think will be an altered post-pandemic environment. Next slide, please. Where's that? I think that's the last one. Great. I'll turn it back to Emily for the questions.
Thank you, Peter. And just to reiterate, since I have noticed some asking, slides will be posted immediately following the webinar, and the video playback will be available within 24 hours. And you'll be able to access both of those in the link provided in the chat. So thank you all. We do have some questions. One of the first questions that we saw was by Robert. If the Supreme Court justices dissent from another justice's decline to block enforcement, what happens? And I believe this was an earlier question directed to Layla's presentation.
Sure. Yes, that's a great question. The dissent doesn't change the opinion or the decision of the court, but it is, interesting to note what the dissent has said or what arguments are being made in the dissent as potential. We often try to predict or opine what the Supreme Court might do in the future, and oftentimes that is by looking at dissents or different opinions. And in that case, it doesn't change the decision, but it might indicate, future rulings.
Thank you. And to follow up, I believe we have just a couple more on that. By Kevin, is there still time to appeal the Fifth Circuit case on executive agency for employees to a Fifth Circuit en banc panel?
I believe so. I know that the Fifth Circuit in this case has declined to stay the lower court's injunction, but there's still time, of course, for this to be appealed again, and there is an ongoing appeals process in place here.
The Fifth Circuit is where liberal policies go to die.
Great. And
so you can, it would be a way to go from there to the Supreme Court, but what we've seen is the U.S. Supreme Court not overruling the Fifth Circuit's rulings. Just take Texas SB 8, for example, on abortion. It's just in judicial purgatory right now. And that's what will happen to this case.
And
that is too true, Peter. We have seen a lot of notorious public health decisions come out of the Fifth Circuit lately.
Yeah.
To follow up on that, by Gwyneth, what's the authority rationale for allowing resubmission to a second justice?
So in that case, that is a very rare procedure where if a case is submitted to one justice who oversees their district and that justice declines to refer the case to the court, in rare cases, and it's not encouraged, it can be submitted to a second justice. This did happen recently. I think it was Kagan that had denied to hear a court case, maybe Sotomayor, and then it was resubmitted to Gorsuch, who did refer that case to the court. So it is rare, but it can be done.
And we have a question by James. For the panelists, what are the premier existing vaccination-related authorities that are at risk of being curbed via the statutory or judicial limits?
I can perhaps start us off with that, and then, Erica and Peter, you can share your welcome your insights as well. I think at least taking the state aspect, Peter referenced this as well, but the concern about more broad restrictions on vaccine requirements. The Georgia bill, was the example that the original wording was so broad that there were concerns that it would go beyond the COVID-19 vaccines. And if that's the case, then that, really pulls back that state, what's traditionally is done with states requiring vaccines for school entrance. And I think that would be the statutory aspect of it. Peter or Erica, if you want to talk more about the judicial.
Erica?
Yeah, that's a great point, Leila, about the broad mandates not being upheld. The court had really strong language to describe the OSHA mandate, saying that it was just very broad and they could not possibly uphold it. But with that particular mandate, that was actually a scaled back version of the original rule. So even when agencies do try to finally tailor their rules, they're not necessarily safe. OSHA had tailored their rule to really focus on the Omicron wave that was hitting us at the time. So the broad ones may not be safe. The narrower ones, the court is more inclined to let stay. And of course, they've been favorable towards state vaccines, their state policies. But as they have some upcoming challenges in the works, that could change too.
Yeah, the only thing I want to add is, again, to shift the focus away from COVID-19, which we're all hoping will be soon endemic, is to what are the effects on not just other vaccine mandates, but generally on public health. So I would broaden that question to have us think about what this means for other public health interventions. Are we going to see resistance now become a daily fact of life? And I don't necessarily mean the vitriol and the attacks that we're seeing in the threats, but rather the unwillingness to comply, that the questioning of public health authority. I don't know the answer, but that's my concern. It's not, so I would broaden the question out for us to think about as a community.
And we have a follow-up to that, which I think in a way has been answered, but will the Supreme Court require a religious exemption to all vaccination requirements? What's your prediction?
I predict no, but I think that what may happen is on a case-by-case basis, the court will edge toward that, but I don't know that they'll go so far, and which may be tantamount to a broad religious exception. A lot depends on how you interpret the Hobby Lobby case, and whether you think the court is basically signaling, again, that Sentinel effect, signaling if your law, policy, or regulation, whatever, affects religion, you better have a good reason for it, or we're going to block it. That may be the standard that comes out a very high burden on policymakers when religion is involved. The obvious problem is whether it's just religion or a personal belief or religious institutions.
Yeah, that's a great question. Because of course the courts want to respect anyone's sincerely held religious beliefs, but the way they've treated religious exemptions in the past has kind of been a mixed bag. Even looking before COVID, with different states' internal vaccine policies related to school requirements or others, some states don't have a religious exemption at all, so parents don't even have the option to request that. And then looking at these recent challenges to the military mandates, the ones that we're seeing right now in court are all religious exemption challenges, because I think the Air Force and I want to say the Navy have had around 3,500 religious exemption requests, but they've only granted a few hundred of these. So it's really not clear what the standard is, but courts seem to be willing to leave this to the agencies themselves to decide. But yeah, that's very interesting to see what's going to happen in the future. And Leila, I know we have some upcoming Supreme Court cases looking at that.
Yeah, I agree with Peter and Erica. I think it may be as Peter mentioned, kind of a slowly limiting, which, but not a full outright, requirement that religious exemptions always be perhaps allowed. But I do think we'll be watching closely and watching to see where the court does go with that.
And Connie posted a question in the Q&A. When talking about religious exemptions, does a person have to not have received any vaccines, such as a Christian Scientist, or can someone claim religious exemption for a COVID vaccine, even if they take other vaccines? I'll defer to the lawyers, but I think the answer is you can claim a religious exemption virtually for any reason.
I agree. And with that, that standard of sincerity of belief, sincerely held belief, it is generally presumed that that is a genuine belief when making a request for religious exemption.
Yeah, and the courts won't question it, won't get to the merits of it.
Yes, exactly. Courts will never probe to see how sincerely held is religious belief. They will defer on that.
Great. And to follow up again on these challenges, this question is directed actually to Peter by James. May tort litigation step in to correct for anti-vax sentiments going forward by allowing greater access to lawsuits targeting harms to others during outbreaks?
I think the answer is no, for a number of reasons. But again, James raised a broader question of what's the role of litigation in public health. We've seen in tobacco litigation where it really mattered. It forced the release of documents and ultimately led to the master settlement agreement on Medicaid policy. With opioids, maybe with recent on the gun case that was settled for millions of dollars and will result in the release of voluminous documentation, that's a positive. But in general, I'm a skeptic about the role of tort litigation in either setting public health policy or, in to James's specific question, allowing the courts to target harms to others during outbreaks. I think there's some causation problems that you'll face in tort litigation. How do you determine the cause of my injury when you have a pandemic? There may be some standing. Of course, if you adopt SB 8 in Texas and allow vigilante justice, maybe that's a solution. My apologies for the snarky remark, but in all seriousness, it's worth, that question is worth a separate webinar to answer, but I'm skeptical that tort litigation is going to achieve that kind of result.
Great. And another question about litigation is referring to constructive discharge as a cause of action for health officers driven from office. If Gerald could elaborate a little bit, but I have a feeling.
I mean, I assume the question is, can the health officer sue? So you've got, I guess it has two parts. Can you sue? Can you identify the individuals who have done it, who have forced it? And can you sue the county or state for unlawful discharge? A lot is going to depend on state law, where it is. There may be governmental immunity involved. and there may be a voluntary termination. So if I'm the elected official, am I responsible that you were driven from office and because of a mob action? Probably not. And who are you going, because I have at least qualified immunity in almost every state. And then how are you going to identify whom to sue for causing your pain and suffering, emotional distress? But I'll defer to the lawyers on the panel.
No, that was a great answer, Peter. I have nothing to add.
Agreed.
Great. Well, we've reached our time here for our webinar. We've reached the end. I want to thank our panelists, Peter, Erica, and Leila. This has been a great webinar to learn about vaccine mandates and really assessing their legalities and policy implications. I would like to again reiterate that this webinar will be available on the website for the next 24 hours. Thank you everyone for attending and have a great afternoon.
Thank
Bye.
you.
Thanks a lot.
Thank you so much.